Welcome back, ladies and gentlemen. Mr. Shaw here, once again, this time finishing the trilogy of the judicial branch of the United States. I hope that this trilogy that I have compiled will be, kept in the Hall of Fame with, Star Wars trilogy and, the Matrix trilogy. Who knows? Maybe even the Dark Knight trilogy. I don't know. Time will tell. Okay, but regardless, there's still one more story to tell. The Supreme Court of the United States. Let's get to it. Anyway, so the Supreme Court was the only court created in the Constitution. Again, as I mentioned in the first video, in Article 3, it is composed of 9 justices, and that is made up of a Chief Justice and then 8 Associate Justices. Again, the Chief Justice doesn't really have any extra power or anything like that. Again, his vote counts the same as any other justice, but again, he kind of is in charge of keeping people organized. I say he, currently it is John Roberts Jr., and we'll talk about that in a later slide. It is the Supreme Court is the last resort for questions about federal law. So again, if there's disputes about federal law, or if the lower courts, the district and appellate courts, rule differently on the same law, the Supreme Court is going to step in and try to resolve that dispute. It also has the final authority on the meaning of the Constitution. And this is really important because we want to make sure that the Constitution is clear and it really means the same to everybody. And so the Supreme Court is going to step in and try to make sure that that happens. You guys have already learned about a lot of different court cases. You think of things like Tinker v. Des Moines, or Gideon v. Wainwright, and these sorts of court cases where there's a constitutional issue in question. And, in Tinker, it's the First Amendment freedom of speech in schools. And then Gideon, it's the Sixth Amendment right to an attorney. And the Supreme Court steps in and they say, okay, this is what this means. Okay, and then everybody has to follow them. And we'll talk about that a little bit more later, why that's kind of a weakness of the Supreme Court. But again, that's kind of the purpose of the court itself. They wield the extraordinary power of judicial review, and this is basically the ability to decide the constitutionality of the acts of government, more specifically the laws of Congress or the actions of the president, such as executive orders and things like that. Okay, now, why do they have judicial review? So this was established in the court case of Marbury v. Madison, and I'm just going to give you kind of a brief rundown of the case, and we'll talk a little bit more about it in class. It's super interesting, but it is a little bit complicated. So President John Adams attempted to appoint this guy named Marbury to a position, but Marbury never got the official document that would have given him the job. So that and President Adams was appointing people at the very end of his presidency, literally like the last day, the final hours of his presidency, he was writing all of these appointments. And so the next day, since Marbury didn't get his job or didn't get the official document giving him his job, now President Jefferson takes over and he instructs his Secretary of State, Madison, not to give the appointment to Marbury, because again, they're not of the same party, and Jefferson wanted to appoint his own person. So again, President Jefferson refuses to give Marbury the appointment. Marbury sues, saying that the appointment should have been his, and then it eventually gets to the Supreme Court of the United States. That's what SCOTUS means, if that's not clear. So the decision of the Supreme Court, they said that Marbury should have his job, but the Supreme Court can't give it to him because the law granting them the power to do so is unconstitutional. So basically, again, real quickly, you don't need to know all these specifics, but like there was a law called the Federal Judiciary Act of 1789, and it granted the Supreme Court the writ of mandamus, and or it allowed them to do that, to issue these writs of mandamus, which would allow them to enforce their own decisions. But since that wasn't in the original Constitution, the Supreme Court said that that law was unconstitutional, and they could not, therefore, give Marbury his job. But this establishes the ability to declare laws unconstitutional. So basically, they kind of give up one power in order to achieve a much greater power of judicial review. And that's really, really important. Without Marbury v. Madison, the entire court system as we know it would be completely different, and the judicial branch as a whole would be far, far weaker than it is right now. They're already weak because they still have to rely on the president to enforce their decisions, but they would have been, much weaker if they couldn't declare laws or actions of the president, laws of Congress or actions of the president unconstitutional. So again, 3 big takeaways from Marbury v. Madison. The first one is the Constitution is the supreme law of the land. Number 2, if there's a conflict between the Constitution and any other law, the Constitution rules. Okay, and again, the justices in Marbury stated that the Supreme Court had to be the arbiter of the Constitution and ensure that everything else in the government is in line with the Constitution. And then number 3, the judicial branch has a duty to uphold the Constitution. I kind of got ahead of myself here, so sorry. Thus, it must be able to determine when a law conflicts with the Constitution. Put a star by that one. That's probably the main takeaway from Marbury v. Madison. But again, if you want just the main thing that you need to know, for the test for Marbury v. Madison, it established judicial review. Okay. So let's get into jurisdiction. Again, you guys know about the 2 types of jurisdiction. Interestingly enough, the Supreme Court actually has both types of jurisdictions. So it's mainly an appellate court. They mainly have appellate jurisdiction. Again, you know that is the power of a higher court to review the decisions of lower courts. Again, it creates what's known as case law, which, again, I'm not super worried about you knowing what that means. And then just the last part here is that it carefully selects and schedules the cases that it chooses to hear. Again, it doesn't they don't listen to every single case that is appealed to them. Okay, there's about 8,000 cases a year that are appealed to them, and they only hear about 80 of those cases. So this is really important because they're only going to deal with cases that affect a lot of people and they raise really important constitutional questions. So that's the appellate part of what they do. Again, that's going to be in reference to federal law, constitutional issues, or anything that is like resolving. If 2 courts rule differently, then they're going to try to resolve that dispute and iron out that difference. The other type of jurisdiction they have is original jurisdiction. That is less common. Again, you know that the definition of original jurisdiction is the power to hear a case for the first time. This is going to involve 2 types of cases. The first case is cases that involve diplomats from foreign countries. This doesn't happen very often because usually what happens whenever there's a foreign official that is accused of something, they usually get sent back to their country to face trial there. So it doesn't really ever happen very often. And then the other case or other types of original jurisdiction case is disputes between states. So if like Missouri and Illinois had a border dispute, then the Supreme Court would hear that case. So what cases get heard by the Supreme Court of the United States? So they only meet for about 9 months out of the year. They meet from October to about June. And they are going to, as I mentioned on the last slide, they're going to consider a case when it raises important policy questions. Things or really constitutional issues is another way to think about that. When the lower courts reach different conclusions on the same issue, again, like if a district court rules one way and the appellate court overturns it, the Supreme Court is more likely to hear that. And a writ of certiorari has been submitted. So again, if you want to, you appeal your case to the Supreme Court, and then what the Supreme Court does is they grant you certiorari, okay, and that means that they are going to hear your case. Again, they're going to choose very, very carefully. The decisions form case law. Again, what I mean by that is cases are going to determine, the decisions in particular cases are going to determine how all future cases are going to be decided. Okay, and that is what's called precedent, which we talked about in the last video. Again, their decisions, it's going to form precedent for future interpretation of the Constitution and for future cases involving similar issues. So when they select a case, 4 of the 9 justices must agree to hear it, and they schedule it, and then they set it on a docket. Again, the docket is just going to be a list of cases that the Supreme Court is going to hear. So again, when the 4 of the 9 justices agree to hear a case, that is granting certiorari. Again, you probably don't need to know that, but again, that might be a little bit more specific than you need to know. But regardless, now you know it. Okay, so in a Supreme Court hearing, there are... basically what happens is the justices hold a pre-conference where they can kind of discuss what's going on in the case. Written arguments are going to be submitted by both the petitioner and respondent. The written brief then is read by justices ahead of time, and then non-participants are allowed to submit briefs as well. So real quick, just what that means, like this is going to sound, it's very similar to what happens at the appellate court. There's going to be briefs that are submitted by both of the lawyers involved in the case, and then so the justices will read those, but also anybody else that is interested in the outcome of the case can also submit a brief. So like, for example, if there was a law conflicting with the Second Amendment, the National Rifle Association as an interest group might submit what's called an amicus curiae brief. That is basically a brief submitted by someone who's not involved in the case that is just going to state their opinion and try to influence how the Supreme Court is going to rule. So that's the written arguments part. Then there's the oral arguments part. Again, that's like what the actual case, when the case is on the docketing and it's like, hey, you're going to hear this case at 7 o'clock, or whenever, I don't know, 10 o'clock in the morning on February 8th. Both parties involved are going to make their case for 30 minutes per side. Again, both by parties, I mean really it's like the lawyers involved in the parties. And they're going to be questioned by the justices throughout the arguments. It's really, really intense. But again, like these lawyers are probably used to that by now. Then there's going to be a post-conference deliberation and then a final vote. And then 5 of 9 justices must agree before announcing the final opinion. Okay, and so again, in order to get a majority, you just need 5 of the 9 justices. And then whatever those 5 justices agree to, that is going to be the decision of the Supreme Court. So I'm going to get into kind of the different opinions in a second, but I wanted to kind of get into what justices are going to consider when they're deliberating. So first thing they're going to consider is obviously the law. They're going to think about precedents that are set by previous decisions. Again, that's the case law that I mentioned. And the reason that we talk about precedent so much is we need our laws to be predictable. We want the law to be predictable. And that kind of gets into this idea of called stare decisis, which is Latin for let the decision stand. I should say a Latin word for let the decision stand. And we want the law to be predictable, and that's healthy for our society. They're also going to think about changing social conditions. Has precedent become irrelevant due to new societal norms? This is kind of the case when you think about like Brown versus Board of Education in contrast to Plessy versus Ferguson. In Plessy versus Ferguson, segregation was the law of the land, and it was accepted. By the time that Brown v. Board rolled around, yes, it was still kind of accepted, but there were other scientific things that were coming out that were determining or showing the negative impact that segregation was having on Black children and Black students, and that was part of the reason why the Supreme Court decided to rule segregation in public schools unconstitutional. The other thing that is going to be included in some justices' opinions are personal beliefs and meaning personal experience, and then and their opinions. That's not going to be everybody, but that's actually going to only really include the judicial activist judges. Let me talk about judicial restraint first. Judicial restraint is really only going to use the law and the Constitution and precedent to make decisions. But judicial activists are going to use those same 3 things, but they're also going to include their own personal beliefs and then changing social conditions as well when they're making decisions. So again, judicial activists, they are okay with making like big policy changes. They're okay with the judicial branch, affecting policy and affecting, this country in a bold way. And judicial restraint believers want to they want to do that less. They want to leave policy and the laws and impacting those things to the legislative and the executive branches, because those are known as the policy makers. So again, judicial activism and judicial restraint are just 2 kind of philosophies that justices are going to use when they are making their decisions. Okay, so I'm not super worried about you guys writing this down. Again, if you want to just listen to this part, I think that's fine. The SCOTUS decision itself is going to be written, most often written, but the oral decision will also be announced, and it's going to consist of 2 important parts. The first part is going to be the holding. And the SCOTUS, like basically, they're going to explain what their actual decision is. Okay, so a holding is just kind of a fancy word for decision. So they're going to either overturn the decision of the appellate court, they're going to affirm the decision of the appellate court, meaning that they are agreeing with the appellate court, or they're going to remand the decision back to one of the lower courts. That's kind of what happened with Gideon v. Wainwright. Again, they ruled that that states must apply, or they must provide lawyers for citizens that can't afford one. So what they did was they remanded the case back to the Florida courts, and they had to retry the case again, and then Gideon was found innocent. The second part of the decision is going to have the rationale or the legal reasoning behind the holding or behind the decision. Again, this is just the thought process behind what the court decided, and this is what forms case law precedent, which is incredibly important for future cases because, again, remember that we need the law to be stable, and we're going to use precedent to do that. Okay, so some SCOTUS cases do have multiple opinions, and the reasons why we'll get into in just a second. Again, the biggest thing to know is that all 9 justices are not going to agree. They do have the opportunity to write and publish their own rationale, whether they agreed or disagreed with the final decision. So the majority opinion is going to be the opinion of the majority of the justices. That will happen. Sometimes there will be a unanimous decision. It's really a lot rarer now, but it will happen if there's a unanimous vote. Sometimes, though, there is going to be a majority opinion regardless, as long as there's 5 of 9 justices that agree. The concurring opinion is going to be written by a justice who agrees with the court but has different reasons for their decision. And then there's the dissenting opinion can be written by a justice who disagrees with the court, with the majority opinion, and they are going to and they're going to explain why they are, why they disagree and why they think the court should have ruled in a different way. The dissenting opinions don't have case law influence, but their decisions can still be used as precedent, and that is what happened with Plessy versus Ferguson and Brown v. Board of Education. There was a lone dissenter in Plessy, and they kind of used that partially anyway as precedent to rule in Brown v. Board. Okay, so again, how does someone become a Supreme Court justice? Again, going all the way back to the original, slide 1. Again, the president is going to seek not to nominate somebody from his party. Again, they're going to want to. There are no age requirements. There are no requirements actually. Just the president's going to want to support appoint someone who's going to do a good job, who has a good record, and is hopefully probably going to serve on the Supreme Court for a very long time. Again, since it is a lifetime appointment, if you appoint somebody in their 40s or 50s, they are probably going to be on the court for the next 30 or 40 years. Again, remember that the Senate has to approve of all Supreme Court justice nominations, and again, as I said, there are no term limits on Supreme Court justices. Again, hopefully you don't necessarily need to write all this. Again, if you want to write this, that's fine, and then you can just write the write the answers. Again, this one I think when you talk about guidance is talking about senatorial courtesy, but again, we've covered all that already. There is one major difference. Presidents usually appoint people who share similar political policy decisions. The appointment of Supreme Court justice has been used to influence long-term public policy. So basically, the president is going to appoint somebody who agrees with them politically, and the reason they do that is so that they will they are basically going to have an impact on the United States policies for many, many years to come, even though they're only going to be in office for 4 or 8 years. Like President Trump was only in office for 4 years, but he was able to appoint 3 Supreme Court justices, and so he's really going to have an impact on the policies in the United States for a very long time. Okay, this is the current makeup of the Supreme Court. Actually, Stephen Breyer just announced his retirement, so he's going to be replaced by President Biden pretty soon. But this is the current makeup. Again, we have Chief Justice John Roberts. Again, he was appointed by George W. Bush in, I believe, 2007. Again, Sam Alito Jr. Was I think he was appointed by, I want to say, he might have been appointed by W. Bush. Regardless, it doesn't matter. But again, he was appointed by a Republican, as was John Roberts. Stephen Breyer, again, just announced his retirement. He was appointed by a Democrat, which was Clinton. Clarence Thomas is one of the old. I think he is actually the oldest serving member. Oldest serving or second oldest, and he is only the second African American to ever be appointed, and he was also appointed by, I believe, George H.W. Bush. Sonia Sotomayor and Elena Kagan. I believe Sonia Sotomayor was the first Hispanic woman to ever be appointed. Also, she was the third woman to ever be appointed total. And then Elena Kagan was also, both of these women were appointed by Barack Obama. And then these last three are the ones that were appointed by President Trump. So again, Neil Gorsuch, Brett Kavanaugh, and then Amy Coney Barrett. And they are the ones that are most kind of just getting into their either their first or second terms, maybe third. I guess Neil Gorsuch has been on for a little while. But regardless, they are still we're still kind of seeing the impact that they're having on the court. Last thing here is just a quick chart showing you Supreme Court nominations. Nothing really that you need to understand specifically or anything that I need you to know. The only thing I really wanted to point out to you was you kind of look at the confirmation votes here. So you go back to, all of these here, like again, going back to even like 1981, 1986, 1987, you see that there are going to be most of the justices that are confirmed are going to be, pretty not unanimous necessarily, but there's a lot more support, across the parties, even though, you see the Senate makeup is pretty divided still. The Senate's pretty much always divided, but there's a lot more support for these justices. Now you get to the Supreme Court. If you go like to Brett Kavanaugh, and again, this doesn't have Amy Coney Barrett, but the division is much more extreme. Okay, and so you can see that only one Republican didn't vote for Brett Kavanaugh, and so like this, it's just becoming much more divisive. Again, you see that happening here, and that really kind of starts, I guess a little bit with John Roberts, but again, really with Sam Alito. That was appointed by George W. Bush. Again, you kind of start to see those divisions mounting. And again, it's a big fight because the Supreme Court is so powerful, and you want to make sure that you're putting the right people on there. But both parties now, recently anyway, have been fighting, tooth and nail to make sure that they're getting these nominations, and they're trying to obtain or keep a majority on the Supreme Court. Guys, I talked for way too long. I apologize. All this stuff is super interesting to me. I hope it is interesting to you as well. But regardless, we are all done with the judicial branch. If you have any questions, let me know in class. Otherwise, I appreciate your time, and I'll see you in the next video.